All right, I want to show you just a little bit more of the Kelsey Thomas opening statement by the prosecutor, because the prosecution's really going to be laying this out for us, all of the facts they intend to show. Let's take a quick look.
You'll also read a letter written by Kelsey Thomas at the end of her interviews with law enforcement saying that she's sorry for doing this, that she needed help, and that her family should have stepped in and helped her. You'll see the time she spends writing that note, and you'll get to decide whether that's coerced or not, whether that's credible or not. And frankly, you'll see all the rest of the letter, and you'll get to decide what type of person would write it to some extent. You'll get to decide the credibility of the person that writes that wording in light of everything else. By the end of the state's presentation of evidence, we expect that you find Kelsey Thomas guilty for homicide in the first degree for killing her daughter, for wrapping pajama pants around her neck and strangling her, and then admitting to it through interviews with law enforcement, but also interviews with her own, or discussions with her own husband during a jail phone call. In light of all that evidence, we expect that you'll come to what we will assert is the only reasonable outcome in this case, and that is that Kelsey Thomas murdered her daughter. Thank you, ladies and gentlemen.
All right, so the jury obviously did not come back with a verdict in which that prosecutor believed they would come back with. But talk to me about this, though, because this is a little peculiar. Typically, when we see two charges and we're talking about an acquittal on one and a hung on the other, usually it's flipped. Here, we have a hung on the top charge and an acquittal on the lower charge. Oftentimes, we see maybe an acquittal on the top charge and they're hung on the lesser charge, or they're guilty on the lesser charge. This seems a little bit different than usual. Can you kind of talk to us why that might be here?
Yeah, so it's definitely different than usual, because usually what we would see when we're dealing with what ultimately happened here, which was a mistrial, is that jurors will come back with a conviction on the lower charge and have a mistrial declared as to the higher charge, because the jurors are also taking into account what is going to happen if this person is convicted, because it's going to be a long sentence. And the lower charge here was not a long sentence. So what I was looking at is that for murder in the first degree, which is what this woman is charged with, she is facing life in jail without the possibility of parole. What I am curious to see is whether the defense attorney was able to ask at the time of trial whether the judge would instruct them in the alternative of murder in the first degree to instruct them with murder in the second degree, which requires or doesn't allow for more than a 50-year sentence. So I think it probably would have given that option to the jury. The jury may have been able to just compromise and find her guilty of probably murder in the second degree as opposed to the higher count. But then again, with jury deliberations, you just never know what's in the mind of the jury. You don't know what's hanging them up. You don't know what's stopping them from coming with a verdict, because in the end, it is kind of finite for them and something that they will remember for the rest of their lives.
Yeah, and Dina, Doll, in the same kind of vein that Bernardo is doing, whenever I have the situation where I can't understand where or how the jury got to conclusion, I like to just speak it out. And so for me, this one doesn't make sense when I speak it out, because the second count is child endangerment resulting in death. Now, the jury didn't believe there was child endangerment resulting in death, and so they acquitted. But they were hung on the idea of actual death. That one kind of left me scratching my head, because you would think that if you acquitted on the lesser charge of child endangerment resulting in death, that you'd also acquit on the murder. And that kind of didn't really make sense to me. So, because how else could the child have been murdered but child endangerment resulting in death? How do you kind of square that peg thinking about this one?
Exactly. That was, I thought, very kind of unique as well. And which is why I thought, well, maybe the coronavirus has something to do with it. Because as you said, it would make so much more sense if the reverse had happened and they said that she had endangered her child in some way. And so for me, when I can't make sense of something with the facts in front of me, I see if there's some sort of like outside influence. And it is possible that the jurors were not convinced that she murdered her child, but they thought there were enough facts that they didn't want to acquit her outright, and they did not want to spend the time that it would have taken to deliberate. There must have been some jurors there that did not want to acquit her outright on this. And like I said, maybe with this expediency of time, this virus is like descending on everybody. They didn't want her to walk free. They wanted maybe another jury, to look at these same facts. They didn't want the responsibility of acquitting her outright, but yet they clearly did not have enough jurors there to think that she convicted any crime, really. So it is speculation, as we've been saying, but to me, that is the thing that makes sense, is that there was some like outside influence, this coronavirus idea. They didn't want to spend maybe the days that it was going to take to convict her, but they wanted somebody else to like take another bite at the apple, so to speak. They didn't want to be responsible for acquitting her outright either.
I don't know if it's true or not, Dina, but it sounds good to me. It kind of makes sense, especially with the lack of facts and the facts we do have. Let's now turn our eyes towards the defense's opening statements and see how they led their way to this split of acquittal and hung jury.
False confessions are a real life thing. And in this case, you folks are going to hear from Dr. Breonna Taylor, who is an expert on interrogation and false confessions. Breonna Taylor is going to tell you about how he reviewed the interrogation of Kelsey Thomas. He's going to tell you about the many known risk factors for false confession that existed during that interrogation. Dr. Cutler will testify that while he can't tell you if Kelsey Thomas is telling the truth, because nobody can tell you if Kelsey Thomas was actually telling the truth, he'll testify that in his expert opinion, that interrogation created an environment which would encourage both an innocent and guilty person to confess. You'll hear Dr. Cutler quantify the number of many different tactics that were utilized in the interrogation of Kelsey Thomas. You'll hear him testify about the known purposes that investigators know in employing these tactics. In voir dire, ladies and gentlemen, he indicated that the circumstances, the context of Kelsey Thomas's confession would be important for you to know. And Dr. Breonna Taylor is going to give you a lot of that context. And context is important. I think both sides agree on that. And because context is important, it'd be important for you folks to know that the evidence will show that when Kelsey Thomas, moments after finding her daughter, called 911, she told the 911 operator what she saw. And then moments after the chaplain at the hospital announced Chloe's death, Kelsey Thomas was whisked away into a private room by another member of law enforcement and asked again what had happened. In the next coming days, the evidence will show, in fact, the next day, that she voluntarily conducted a video walkthrough with the police at their request. That her so-called close cousin, Brittany Johnson, volunteered to surveil and monitor her with no results. And the evidence will show that Kelsey Thomas completely cooperated with every aspect of the police investigation.
I mean, this is interesting, Bernarda. I can imagine first picking up this file and you tell me, all right, you've got a mother who's alleged to have strangled her 5-year-old daughter with pajama pants, and she confesses to it. I would have thought on its face it was a dead loser, but this defense attorney, even through his opening statement, is able to highlight these small pieces of this case that the jury is supposed to focus on. And it seems like it obviously worked because those pieces seem to be what led them to that acquittal of the lesser count and the hung jury on the top count. Do you think that the defense attorney has got his finger on the pulse and is pointing to the right things that need to be evaluated here?
Absolutely. So he's doing the best that he can. So what he's doing is that he's showing the nice acts of the mother, nice acts in terms of, well, if she was guilty, why would she have called 911 right away? Why would she have cooperated with the police? Why is it that when she was being tailored by her sister, that she was still behaving in a normal manner? These acts, as being argued by the defense, is not consistent with someone that is capable to take life away from a 5-year-old child. And obviously, these arguments, being that he set it out in the very beginning, in the opening, gave pause and hesitation to these jurors throughout the whole trial as they listened to the testimony. So the defense did a great job by enumerating these acts in the opening statement as opposed to waiting to closing arguments, because it left those thoughts and those arguments in their heads, in the jurors' heads, as they heard all of the testimony being put forth in front of them during the entire trial. And Brian, I just had an opportunity. I looked at the child endangerment statute for Iowa, and in reality, it does not make sense that this woman was acquitted of child endangerment, but still there was a hung jury as to the homicide charge. Because for child endangerment, you have to have committed some intentional act that caused some kind of bodily injury to this child. So if you find that she did not perform an intentional act, then you don't have the necessary act or premeditation for her to be convicted on homicide charges of murder in the first degree. So I'm not sure where is it that they went wrong or what was in the minds of the jurors. It could be that they thought it was really just an accident, and murder in the first degree doesn't allow for that option of accident. You have to look at the other homicide charges in order to find her guilty in that regard.
So it's interesting, Bernardo, because as I'm listening to you, I'm trying to figure out, so should they have gone bench trial or should they have gone jury trial? And you've kind of made answers for both. Let's take a quick break and we'll dive into that idea after this. All right, the first time around in the case of Iowa against Kelsey Thomas, the defense made out pretty well with a hung jury on the top charge of murder in the first degree and an acquittal on the endangerment of a child resulting in death. You would think they would go jury trial again, but instead, it appears that they might have something up their sleeve. That's the only explanation we could figure out as to why they would choose to do a bench trial, because that is completely their choice. The prosecutor in that state, as in many states, really doesn't have a dog in that fight as to whether or not it's going to be a bench trial or a jury trial. So let's look at the defense's opening statement and see if there's some way we can glean out why they're making this choice.
The evidence will show that from the moment she dialed 911, through numerous conversations, through all of this interrogation, her story remained the same until the very end. And all of this, imagine losing your daughter, and then this is what you face. All within a week of losing Chloe. And these pajama pants that you just overheard the state indicate. Kelsey confessed that she strangled Chloe with. You're going to find that throughout those hours and hours and hours of interrogation, I'm estimating maybe 10 or 12 hours of interrogation, investigators were telling Kelsey Thomas, it is impossible. The science tells us those pajama pants could not have made those marks. And so you have to ask yourself, how is it that after hours and hours of telling Kelsey Thomas that these pajama pants could not have created these marks and could not have been the cause of Chloe Chandler's death, then the investigators decide, okay, we'll go ahead and accept that as long as you're confessing.
All right, Dina, before the break, Bernarda had spoken about two different things. It's almost like she advocated for both a jury trial, but she ended up, I think, settling on a bench trial. The first, she was talking about how some of these facts can cause and hesitation. And when I think about that, I think you send that to a jury because cause and hesitation is the definition of not meeting your burden with 12 people. However, and I think all three of us touched on it earlier, that this didn't really make sense for there to be a hung jury on the murder but an acquittal on the endangerment of a child resulting in death. It's almost like 2 + 2 = 5. And maybe if that math, maybe the defense is banging on that math, not quite equaling out, and maybe that's why they're presenting this to the judge trial. Kind of piggyback off what Bernardo said, does this make sense to you to acquit the lesser charge and hung on the first charge? And do you think the defense has it right to present it in the way that they're doing in front of a judge?
You know, it does not make sense that they acquitted on the lesser charge and hung on the first. I mean, they have to have believed that she endangered her child in order to believe that she killed her child. So no, that definitely does not make sense. And as you know, we've been talking about the defense attorneys here, you know, they actually did an excellent job at this first trial, right? They actually almost got her acquitted altogether. So, you know, I believe they know what they're doing here. And throughout this trial, this judge made rulings. You know, they got to know this judge very well. And the fact that they are now putting her fate in this judge's hands says to me that they feel as if this judge is going to be fair and maybe even sympathetic to the legal arguments that they are going to make in this case. And I imagine after months, you know, there's been months since this trial has been presented, they will have developed these legal arguments even more. There might be more experts speaking on this issue that again, this was their choice and is a highly unusual choice. The fact that they did it, I think that they have a very good reason, and I can't wait to see as it develops these next few days. The arguments are going to be a lot less emotional and a lot more legal.
Yeah. Let's listen to a little bit more of the defense's opening statement. And I think, Dina, they're actually maybe hearing you out because a lot of these arguments are a lot less emotional and a lot more legal, even the first time around. Let's take a listen.
Ladies and gentlemen, this is my client, Kelsey Thomas. Prior to her life being completely destroyed by her daughter's death and its aftermath, Kelsey was a young married woman, mother of Chloe Chandler, age 5, Phoenix Thomas, age 2. Her husband worked up by the airport at Plastipack. She was cooking your pizzas at Casey's General Store. There are Kelsey Thomases in our town and everywhere across this country that, due to their life circumstances, would be an easy target for assumptions. And this is what happened in this case. Any parent unfortunate enough to find their child in the circumstances that Kelsey Thomas found and could not explain would find themselves in Kelsey's position now. And just like the juror, prospective juror that we discussed in voir dire, when she was asked, well, do you remember your wedding? Well, I remember getting married. I don't remember all the details. On July 19, 2018, Kelsey Thomas knows it was burned in her brain. She found her daughter hanging that day. She can't quite explain how she got her down. The fact that she couldn't explain it started all this. And think of the source, as she's the only witness. If this were all just a scheme on the part of Kelsey Thomas, why would she just not tell a different story?
Seems to be working pretty well. Bernardo, this is another thing that comes to mind as well. And we've all three have done trials together. And I always tell people, when you're in a trial, it's the first time the jury's hearing the case. And there are facts and issues that will shock you. And it might have shocked that defense attorney or prosecutor the first time they've heard it, but they've basically been married to this case. And now the judge is in the same boat. The judge knows about this case since March. There's going to be no gruesome photos that's going to shock her. There's going to be no information. She's going to look at it with a very even Kelter mind. just as our viewers are going to do it, so if they've watched the first trial, and they won't be shocked by anything. With that shock value being gone, maybe that is a strong reason to go with a bench trial, because any juror that comes up after this is going to be shocked by this information, and they may look at the emotional aspects, as Dina and you have been talking about, and not so much the factual and legal aspect. Could that be a way of fighting this case?
So, Brian, let's be clear for our viewers. Whether you take a bench trial or you take a jury trial, either one, the prosecution still has to prove their case beyond a reasonable doubt. The law is still the same. The charges are still the same. The evidentiary issues are still the same. The objections and whether an objection is sustained or not will still exist. The only difference now is that because it's the bench trial, one, whether you have any objections to anything coming in, you have the same fact finder, and the person that's making the determination on the law is the same person, as opposed to if it were a jury trial, sure, a judge can sustain an objection or overrule an objection, but he's not ultimately the fact finder. It's for the jury to actually decide. So now it's going to be a lot more focused into technicality of what the elements of the crime is. And that's what the defense attorney and both the prosecution are going to hone into. I will say, Brian, that watching the defense opening and the prosecution opening, two completely different styles. As you see from the defense opening, the defense humanized Miss Kelsey, humanized her, made her a person, told you who she was, made her someone that you can picture. Like he even said, like, Kelsey is a person that you see all around this country, all around this world, which is different from what the prosecution did, where the prosecution simply told you, this is what we're going to prove, and this is how we're going to prove. This person's going to say this person's going to say that, which is not as effective as the defense attorney was when the defense attorney humanizes an individual, which I think has a huger impact.
Yeah, and that impact is going to be felt regardless if it's a jury trial or a bench trial. It's going to be interesting to see how that style, both in the prosecutor and the defense, either stays the same or changes. We won't know until tomorrow, but stay with us. We got a little bit more diving into the old case before we start back tomorrow. We'll see you on the break. Good afternoon and welcome to the Law&Crime Report. I'm your host, Brian Buckmire. We begin with an update of the George Floyd case, specifically that former officer Derek Chauvin, who was out on $1 million bail, was given another little bit of freedom in that he could go to any of the neighboring states. Now, the Department of Corrections cited possible dangers that he would face, either being housed in correction facilities or in the state of Minnesota. We don't quite know because those details were not given. I'm joined with Bernardo Villalona and Dina Dolla. Good afternoon to you both. Dina, let's start with you. It seems a little peculiar, but hey, this case is a peculiar one, that a defendant who is out on bail is allowed to leave the state. Now, it's only the neighboring states, so it's the Dakotas, both north and south, Iowa and Wisconsin. Of course, he can't go north to Canada, but what are some of your thoughts on his ability to go to these 4 other states for safety that he's claiming?
Well, like you said, this is an unusual case, and I imagine that they probably have a lot of precautions in place. He probably is going to be having to check in regularly, and who knows, with technology, there may even be some just all the time monitoring of him. And so although it's unusual, I could see them doing something like that. The safety thing is odd. I don't know if there's more there that we just don't know that was private, because you would think that he could find some location in the state of Minnesota that would be safe. It is a large state. But as we saw with the Michigan governor recently, I don't know, there's all sorts of things that are underneath the radar that we as a public just sometimes don't know about.
Yeah. Now, for the most part, what I'm hearing, Bernarda, and this is what I want you to kind of tap into your former prosecutor life just for a moment, then you can come back and be a defense attorney with me. He's supposed to keep in touch with his conditional release officer and have his phone on him at all times. I would have thought that the prosecution would have asked for an ankle monitoring bracelet so they can actually physically see where he is and not just be able to call him up from time to time. Do you think that this ability to leave the state and not have a greater way of tracking him is kind of a misstep, or do you think this is proper?
So, Brian, the whole purpose of bail is to secure a person's appearance in court. So, obviously, the judge set a high enough bail, that being $1 million, that if he were to make the bail like he did now, it is to deter him from losing that amount of money. If he were to skip trial or skip a court date, obviously, he will lose that $1 million. That's why it was set so high. So in this case, one, you're dealing with the parameters that the judge set, but you're also dealing with the parameters that was set by the bail bondsman, because sometimes the bail bondsman, their parameters are much more stringent than that of the judge. So in terms of getting electronic monitoring, it probably was not feasible because I think you have to be within a certain range in order for you to get the notifications of where the person is. So what I would take from this case is, one, that the judge told him that he can't leave the country, and if he had a passport, he had to turn that passport in. Two, that he has to check in any time he decides he wants to leave the state. He either has to let the court know, the Department of Probation know, or actually definitely let the bail bondsman know where he's going. And three, he has to appear at all court appearances, because in the end, the purpose of bail is to ensure your presence in court. And two, he hasn't been convicted of any crime yet. That's why he is allowed to be out on bail.
And just throwing this out there as well, this might be a situation where the coronavirus might actually give him more ability to move around, because if I'm a defense attorney, I would say, Judge, what country can he go to? He can't go to Canada. He's an American citizen. They'll stop him at the border. He can't fly to a different country for the most part because of the virus. Simply allow him to stay here in one of the 4 neighboring states. It might actually help him in terms of that argument, but we're going to continue to follow that case, of course, until it goes up until trial. He is one of the, I think he's the last now defendant of the George Floyd case that is out on bail. So all the defendants are out now. Let's switch gears and go back to the Iowa v. Kelsey case, where we are seeing now a bench trial starting tomorrow. Let's begin with the defendant's mother, who spoke at court.
Did you ever have any conversations with Kelsey about Chloe?
Yes.
What kind of things did you talk about relating to Chloe?
She would be having a hard time getting Chloe to listen, and I just told her to try to spend as much time as she could with her.
And why did you tell her that?
Because I thought maybe if she spent more time with her and paid more attention with her, that she would stop being a brat.
Did you ever have a conversation with Kelsey specifically about Chloe coming to live with you?
Yes.
When did that conversation take place?
Like a year prior to the...
So would that be about a year prior to Chloe's death?
Yes.
So approximately 2 or so years ago. And was that conversation in person or over the phone?
Over the phone.
What did Kelsey ask you during that conversation or say to you?
She pretty much told me to take Chloe.
And what was your response?
I said, no, you would miss her too much.
And why did you say that?
I would miss her.
When was the last time you saw Chloe prior to her death?
That birthday party.
Did you ever go with Chloe to the zoo?
Yes.
When was that in relation to her death?
May.
Would that be May 2018?
Yes.
So approximately 2 months before her death.
Yes.
Why did you go to the zoo?
It was my birthday, and that was my birthday present from Kelsey.
Who did you go to the zoo with?
It was me, Chloe, Kelsey, and Larry.
Was Chloe walking around that day?
Yes.
Did Chloe know how to tie her shoes?
Yes.
Do you know who taught her how to tie her shoes?
No.
Is there anything specifically you remember while you were walking around the zoo regarding her shoes?
That we had to keep tying them because she couldn't get them tied that tight.
What I thought was interesting about this, and Dina, and I'll ask you about this, for the defense, I thought they had some strength in some of their arguments combating that of the prosecutors, because especially with this witness, it sometimes raised the question for me, is this a mother that's over her head because she's a 24-year-old mother raising a 5-year-old, or is this an abusive mother who is just on the verge of killing her child? That kind of always ran through my mind here, especially when I listened to this witness. What did you hear, or what came to mind when you listened to this and other testimony in terms of who Kelsey Thomas was as a mother?
Yeah, I was really trying to hear this testimony to see what the mother thought. Did she think her daughter was guilty of killing her child? And that mother really kept that really close to her chest, I thought. She really didn't give the answers anything more than she absolutely had to. So if I were sitting there just as a juror, or now it's going to be the judge, I don't think I could even speculate whether or not that mother thought that her child was guilty of this crime. It's possible that she feels some guilt for not having taken in the child, because the fact that she was asked to do that, we know that Kelsey was feeling overwhelmed. Was it enough to actually kill her child? That we don't know, but it is kind of just sad. She did ask for help, and the fact is she was not given any help here by her family.
Do you think this witness, Bernardo, could have been a piece of the reason why they had that hung jury charge for the top charge? Because again, as Dina's saying, maybe this testimony is a mother concealing that her daughter actually murdered her granddaughter, or maybe it's just the guilt of a grandmother saying, if I only listen to my daughter and take in my grandchild will be here. It's kind of hard to parse through what those emotions are or what those mindset are when you don't really know the person except for them on the stand. How do you think a juror or even our audience should really kind of grapple with who this person is as she testifies?
Yeah. So this loved one obviously is putting a human factor into Kelsey Thomas. We're seeing who she was. If she really wanted to cause damage or any kind of hurt to her child, then she wouldn't have been seeking out for help. Obviously, she's seeking out for help because she wants the best for her child. And I think that is what the jury was grappling with, was like, if she was this horrible mom, why would she be seeking out for help? There's no issues in the past. She still cared for both of her kids. So there is no pattern of her being abused or being neglected.
Yeah, it would be interesting to see, as Dina and Bernardo, you both talking about it, I wonder if a psychiatrist spoke with her, and if that psychiatrist did, do we think that psychiatrist could be probably used at the next trial? Because that's a very scientific, non-emotional description of your client that could help at a bench trial. Dina, what do you think?
It's true. I mean, it's tricky because I feel like this whole trial, there's a lot of kind of like, where do you veer on like mom shaming versus she's a murderer, right? Because the fact is, every mother gets overwhelmed. You know, the prosecutor's talking about how she worked so much, right? He makes it so clear she's trying to take a nap before she goes to her next job. You know, there's like a little shaming in there too. And so whatever an expert psychiatrist is going to say is, I think, very difficult. I mean, where is that line, right? Where is that line between just having, isn't every mother entitled to sometimes even get angry, right, at their child and not be accused of murdering her child? And it doesn't seem as if there is any mental illness here whatsoever, right? That was definitely not alleged. And could even an expert parse that really fine line between saying exactly what was in the mind of this mother at that time? I don't know if that's possible.
That's a great point you brought up, and I'd be curious to see how that affected the jury, that concept of almost mom shaming Kelsey Thomas for just trying to take a nap here. I mean, I've been a legal guardian for only 14 years. I'm not a father in any way, so I would never even dream about shaming a mother in terms of how she raises a child. It's difficult in and of itself, and I've only done it part-time. So I think that could have rubbed a few jurors the wrong way. But let's take a quick break, and we'll be back with more of the Kelsey Thomas case, prepping for that trial to begin tomorrow. All right, welcome back to Law and Crime Report as we continue to dive into the Iowa v. Kelsey Thomas case that's beginning again tomorrow. This is the retrial of the case. This time around, it's going to be a bench trial rather than a jury trial, because in the first go around, it was hung on the murder charge and acquitted on the endangerment of a child resulting in death. Let's begin with Brittany Johnson, the defendant's cousin, who testified in the first trial.
She said that she must have accidentally hung herself, and she proceeded to explain how she thought it happened. But during that time, I had asked to enter the residence once we had parked, and she told me that she wouldn't go back in because she had just watched her daughter die.
And then did she then, after she said that, then say, well, not really die, but I found her?
She did. She corrected herself.
Did you, during that conversation, did you talk about the fact that the police were investigating what had happened?
I did.
And what, if anything, did Kelsey say regarding that?
That she thought she was going to be okay.
Did she give you any indication about whether or not she was happy that the police were investigating what happened?
No, she was not happy that the police were investigating what was happening.
Did she specifically talk to you about whether or not Chloe had ever done anything like this before, like tied anything around her neck or say anything regarding that?
I do not believe so.
Did you specifically ask Kelsey how the pants were?
I did.
And what did she tell you?
That she had tied them into a knot up above the rod, creating a loop, almost like a swing.
Now, throughout your conversation with Chloe, with Kelsey, did you ask her if anyone else was home?
Yes.
And what did she say to you?
That there was no one else home.
All right, Dina, what are your initial reactions when you heard that testimony, either in the first trial or just now?
I don't really find this cousin to be that persuasive in terms of like showing Kelsey's guilt. The statement that she said, oh, I watched her die, and then she corrects herself. I think that could be a very easy, misstatement or something like that. The fact that she's a cousin still doesn't mean that they're very close and that somehow this family member speaking out against Kelsey shows that there's some overwhelming evidence against her. In fact, actually hearing her, I've read a lot about what she said before, but hearing her makes me even less in her corner, so to speak. Again, if I were the jury, I could see why this testimony wasn't enough to convict. To me, it's not either.
Yeah, Bernardo, I can see either side, prosecutor or defense attorney, taking this statement and kind of molding it into something that's beneficial for them. And it's hard to use a baseball analogy, but the tie goes to the runner, and the runner in this case would be the defense. And so if it's equally plausible on either side, does this witness really help the prosecution out?
So, Brian, the point that helps out the prosecution with this witness is that this witness says that Kelsey told her there was no one else in the house. So by saying that no one else in the house, obviously it takes out the realm that it could have been someone else that was involved in the death of Kelsey. So she is the only one, the only suspect, if any, if it was any foul play, that is to be considered. So that's where it really helps out the prosecution.
Yeah. All right, let's listen to the medical examiner's testimony now from the first trial, and let's really parse through what the jury thought about, because I think this is going to be the major point of this trial and was in the first trial in deciding guilt or innocence. Let's take a listen.
What physical evidence of strangulation did you find on Chloe?
Well, first of all, there was a ligature furrow. A furrow is what we call a patterned injury that's on the neck in terms of strangulation, and that reflects the presence of an object that caused constriction of the neck, most often some kind of ligature. That is actually an abrasion, often combined with a contusion, and sometimes just pressure marks. So that ligature mark is one of the signs that may or may not be there. Internally, we look at hemorrhage, which is essentially a bruise, and the bruise can occur at many layers of the neck. Sometimes it's not there at all. A good part of hangings, the hanging deaths we see, do not have any injuries in the neck whatsoever. And that has to do with the completeness of the constriction and the location of the ligature. But there may or may not be that injury in the neck. Further in the neck, deeper, are hard structures. The Adam's apple is actually a piece of cartilage. It's shaped like a shield, and it's part of the larynx where the vocal cords are on the inside. That cartilage can be fractured. In older people, it actually turns, at least partially, to bone oftentimes, and that makes it easier to fracture if a person's older. There's also a horseshoe-shaped bone above that Adam's apple area, kind of way under the chin, which is called the hyoid bone. Muscles that control the tongue and the swallowing structures and so forth connect to it, and sometimes that can be fractured. Rarely, even deeper structures can be fractured, like the vertebral column, the spine that lies behind all those laryngeal structures. And also very rarely, sometimes muscles in the back of the neck can be injured. I talked about the fractures. Oftentimes there are no fractures in the front of the neck, but there are layers of muscles there, and those muscles may have injury as well. Sometimes they're very subtle, and sometimes not so subtle.
All right, so we know that in this case, they were able to describe strangulation as the cause of death, and that's something that the defense and the prosecution really tried to split hairs with to show how this occurred and who was guilty and the manner in which it occurred. Dina, Doll, what did you make of this witness's testimony so far?
Well, so far, you know, it's interesting. She said that it wasn't consistent with the hanging, right? But in my mind, I'm thinking if a child is going to be making a swing on this bedroom, you know, closet wall pole, there might be a leg involved in there, right? I mean, a child wouldn't literally just go and put their head in this to make a sling. They're probably going to try to get themselves into the sling, like maybe put their leg in the sling or an arm in the sling and then somehow get caught up, right? If this is the defense's argument. So that's why I think this is a really unclear case, because if she did, you know, there is that possibility that there was some sort of strangulation, even in this swing idea, that the child wouldn't have gone and literally just stuck her head in the pajama pants and hung herself. She was trying to create a swing. And that to me does create some sort of gray area, even with this medical testimony.
I actually really like that argument. I hope the defense is listening now, because Bernarda, what do you think about that? It's not how the child's body was found, but what could have happened to her, and then her body may have rested in that final position. That sounds like reasonable doubt to some degree. How do you think the ME's testimony is going to be used in this future trial starting tomorrow?
Well, the medical examiner's testimony is going to be crucial. It's going to be the number one top testimony that both sides are going to have to tangle with. Because if you can't prove the manner and cause of death to be homicide, then you do not have any homicide charges. If you have doubt as to how she died or whether this can be an accident or not, then that is reasonable doubt, and she cannot be convicted, Ms. Thomas, of any of the homicide charges.
Yeah, it's going to be interesting to see how this plays out. As we've been saying, this is a retrial. We watched the first case. Now, the second time around, it's going to be a bench trial, And Bernarda, Dina, I want to thank you very much for always lending your expertise for us. We're going to continue with this story. We've got Linda Kenny Bodden coming up next. She's going to put her own twist on it. You can't walk away because she's going to explain how this case is going to look out for the rest of the week. Enjoy the rest of your day, guys, and I'll see you tomorrow.